Welcome everyone to today's Explainer. I am so thrilled to have you here. Go ahead and get your notes ready because we are looking at one of the absolute most fascinating, massive structural challenges in international law today. We're talking about the architecture of accountability. You know, we hear about global human rights all the time in the news, but today we're going to act like legal architects. We're going to examine the actual structural mechanisms that are supposed to enforce these civil liberties globally.
Okay, let's dive into this because, really, it's the ultimate question, isn't it? Who actually enforces international human rights? Having a list of rights is one thing. Writing a piece of paper is incredibly easy, but enforcing those rights across the heavily guarded sovereign borders of hundreds of different nations? Wow! The sheer scale of that problem is a remarkably intricate puzzle. There's no single giant global police force out there. Instead, making this work requires a really complex, multi-layered system of institutions and agreements.
So consider this our syllabus for the Explainer. We're going to break down this complex web of international law into 6 logical pillars. We'll start with an introduction to global rights, move into charter-based institutions and their protections, then we'll shift gears to treaty-based institutions and their protections, and finally, we'll explore what happens beyond treaties with extra-conventional and regional systems. Let's get right to it. Section 1. Introduction to Global Rights. Before we can look at the specific gears of this machine, we have to establish our foundational baseline.
Everything we are discussing today begins right here, in the ashes of World War II. The United Nations Charter is the governing document of the UN, entering into force on October 24, 1945. And listen, this isn't just some dusty historical artifact. It serves as the absolute primary means of international human rights protection. It established the overarching framework. Literally, it is the bedrock foundation upon which the entire modern architecture of global civil liberties is built.
Moving right along to Section 2, Charter-based institutional mechanisms. Now that we have our foundation, we need to look at the who. Who exactly are the institutional players created by this charter?
Well, the UN Charter didn't just express good intentions. It built a machine with 6 principal organs. First up, you have the General Assembly, which is the chief deliberative body where nations debate. Then, the Security Council, carrying the incredibly heavy mandate of maintaining international peace. There's the Economic and Social Council, or ECOSOC, handling the heavy lifting for coordinating social, environmental, and human rights work. You also have the Trusteeship Council, originally designed for territories transitioning to self-governance. Then, the International Court of Justice, acting as the principal judicial organ. And finally, the UN Secretariat, providing the essential day-to-day advice and administrative support to keep the whole shebang running. Together, these bodies form the core institutional machinery of the United Nations.
Section 3. Charter-based implementation and protection. Knowing the who brings us directly to the how and the what. Specifically, how do these organs implement rules and what protection mechanisms do they use on the ground?
Now, what's really interesting about this slide is seeing how functionally different these bodies actually are. The General Assembly implements through multilateral discussion and protects by making broad recommendations for peaceful settlements. The Security Council, on the other hand, takes a sharper, more forceful approach. They implement through direct negotiation or inquiry, and their protection mechanism involves actual interventions to maintain international peace. Then you have the International Court of Justice. They implement by strictly applying international conventions and customs, and they protect by indicating provisional measures. Think of those as legally binding emergency injunctions to preserve the rights of disputing parties. So every single organ utilizes a distinct, specialized method for enforcing protection.
So we have the broad, foundational, charter-based system derived from 1945, right? It applies generally to the whole UN system. But now we're pivoting to treaty-based mechanisms. Treaties are specific agreements. Unlike the broad UN Charter, they only apply to states that actively consent to and ratify them. General rules are good, absolutely, but specific, binding agreements, that takes accountability to the next level.
Which brings us to Section 4, the next major pillar of our syllabus, treaty-based institutional mechanisms. This is where we get into specialized written treaties and the expert committees designed to govern them.
Over the decades following the UN Charter, there was an absolute explosion of specialized treaty law. The idea spread like wildfire. In 1948, we got the Genocide Convention. By 1966, the massive covenants on civil, political, economic, social, and cultural rights were adopted. In 1979, CEDAW addressed women's rights. 1984 brought the Convention Against Torture, and 1989 gave us the Convention on the Rights of the Child. International rights became highly specialized, targeting the exact areas where humanity is most vulnerable.
But, a treaty is basically just a promise unless someone is actually watching. Therefore, each of these major treaties establishes its own dedicated independent expert body. You have the Human Rights Committee, the Committee on the Rights of the Child, the Committee Against Torture, and so on. These aren't just ceremonial panels. No way. They act as the institutional watchdogs, purpose-built to scrutinize exactly how well countries are living up to their specific treaty promises.
Section 5. Treaty-based implementation and protection. How do these specialized watchdog committees actually force sovereign nations to comply with the rules?
Let's move to and see how this builds into a very distinct legal pipeline. When a state agrees to a treaty, it isn't just a friendly handshake. Step 1 is ratification, establishing on the international plane their formal consent to be bound. Step 2 is where the real heavy lifting happens. They have a legal duty to modify their own domestic legislation to conform to these new international obligations. And Step 3, they must submit to international reporting procedures, allowing those expert committees to rigorously monitor their progress.
There's basically a triad of treaty protection tools at play here. First, the reporting procedure, offering a broad, systemic review of a state's compliance. Second, interstate complaints, where one state can actually challenge another state, leading to formal adjudication between nations. But the third element? That one is vital. Individual communications. Under certain treaties, committees can receive personal petitions. This is a real game changer because it allows regular people a direct line to international justice to seek redress for personal violations.
Now, I really want you to hear this quote. International procedures can never be considered to be a substitute for efficient domestic legal procedures for the protection of human rights. So the absolute crucial point is this. International law is strictly subsidiary to your own country's legal system. The UN and these treaty bodies, they are not designed to be the first responders. They are the safety net. The primary duty of protection always rests with domestic law.
Section 6. Beyond treaties. We're looking at extra-conventional and regional mechanisms, because we have to ask, what happens when the core conventional systems just aren't enough?
What if a state hasn't ratified a treaty, but terrible things are happening? Well, this is where extra-conventional methods come in. The UN, specifically ECOSOC, established special tools. Things like the 1503 procedure, which handles confidential complaints of systematic, gross violations, alongside special rapporteurs and working groups. These are designed to identify and monitor situations of grave, large-scale human rights violations worldwide. The beauty of this is they don't have to wait for a specific treaty reporting cycle. They can examine, monitor, and publicly report on horrific situations exactly when the spotlight is needed most. And we absolutely shouldn't overlook how enforcement is localized through regional systems. Honestly, these often work better due to cultural proximity and direct peer pressure. In Africa, the African Charter created a commission and a court, and uniquely, it focuses not just on individual rights, but on people's rights and duties towards the community. Over in the Americas, the Inter-American system handles mandatory petitions against states, and in Europe, the European Court of Human Rights issues binding judgments, complemented by systems that conduct actual physical visits to prevent torture. These regional bodies often have a much tighter, more binding grip on member states than the broader global mechanisms.
We've covered a tremendous amount of ground today, going all the way from the UN Charter to regional courts. But I want to leave you with a final, provocative thought. If all these international mechanisms we just talked about are ultimately subsidiary to your local laws, who really protects your rights when your own nation's domestic system fails? It is a sobering reminder of why both domestic vigilance and international accountability are absolutely essential. Thank you so much for joining me in this explainer to break down this architecture. I highly encourage you to keep questioning the reality of the protections around you. Keep learning, and I'll catch you next time.